Adam, let's talk about international workers, employees, those kinds of things for US based companies. I would venture to say a majority of companies now have somebody who's assisting who is not in the United States or is not a US citizen. So what are some things from an employment law perspective that people should be thinking about or doing?
Yeah, I mean, first and foremost, anytime you hire anyone, the first determination is, are they W 2 or are they 1099? Because if they're a 1099, the arrangement can be had a lot easier. You can set up an independent contractor agreement, and that should really govern the extent of the relationship, coupled with figuring out how to properly pay someone overseas too, which may have its own issues. If they're a W 2 employee, then it adds some complexity to the arrangement because we've talked about this before. You have to abide by not only your home state's laws, you also have to abide by the laws where the employee is physically located. So if you even have an employee traveling abroad or maybe staying abroad, let's say through a military arrangement, or that is set up remotely indefinitely abroad, now you have to take into account those local laws. And many US based attorneys will not opine on those laws. We're not admitted there. So, unless you want to hire an attorney locally there, which some companies do, uh, the alternative is setting up employment through a staffing agency. And like anything else, some are better than others. What you want to make sure that you do if you're looking at a staffing agency is look at how they handle things like compliance and payroll and abiding by the laws. Because if those are not important considerations from the staffing agency, you need to move on to another one. As you can imagine, there's some other considerations as well.
Is the determination the same for determining whether somebody's an employee who lives in another country? Is that determination the same in the U.S. or is it a little bit more lenient towards independent contractors?
It's once again going to depend on their local laws too, that determination itself. But what I can say is, if you look at things like this is going to be a discrete project, kind of the same way we look at things here, then I think you're leaning at least into the right direction in terms of this being more of a freelancer or a project
Yeah.
based worker versus having someone on an ongoing basis working for you, which for all intents and purposes looks like a W 2 employee.
And then the risk there is partly that they're a W 2 employee, but probably more that you're then doing business in that country or that location because you're actually hiring employees in that other jurisdiction. And so then where does that leave you?
That's exactly right. When you set up shop in another country, you actually have to set up shop there. And
Right,
there are
right.
some requirements locally to properly set up your business in that country.
Yeah.
So it does add some complexities. It can be done. I don't want to dissuade businesses from doing it. I just think that many of them just assume, oh, I'll just hire someone overseas. It's a lot cheaper. But then they overlook a lot of these legal requirements, and then they can be caught out of
Right.
compliance, and there are some consequences associated with that, as you can imagine. Let's turn it to you. What are some considerations from an intellectual property perspective when you have someone working overseas?
Yeah, so it's a similar thing. I mean, every country is a little bit different. Fortunately, there's some similarities between many countries, but what you do remains the same. You need to have written agreements with anybody who's international. Hopefully, those agreements reflect what their actually status is, and in best case scenario, you have somebody local review it to make sure that it's compliant with whatever country they're in. But having a written agreement to make sure that anything that they're developing is assigned to your company, and then also making sure that whatever rules, what other things you want that person to do, it needs to be in their agreement, even though they might be an employee, as we just talked about, because it's so much more difficult to enforce that you really want to have a written agreement in case it ever comes up, so that you can exercise your rights based on that agreement rather than trying to find somebody.
In terms of this agreement, is that something that a US based attorney would prepare, or is that something that you would need someone locally to prepare, or is it both?
So in an ideal world, it would be something that the US lawyer would prepare and that the foreign lawyer would bless. However, in reality, often what happens is that the US lawyer prepares it. If the person's an independent contractor being treated as an independent contractor, it'll state US law for that contract, and then the disputes would be in the US. So that's how it normally ends up getting handled. But yeah, best case is to have local counsel in whatever country look at it and make sure that there's no statute that overrides that.